So we had a unique guest speaker link to use to access. Is that what everyone else used as well?
It's not.
Justine, are you able to hear us and see us?
Yes, I can hear you and see you fine.
Are we ready to begin? On the technical side, is everything in order, Justine?
We are, yes.
Okay, and is the court reporter here?
She is. Her name is Carissa Stadler.
Ah, okay. Oh, there, I see you now. Sorry about that.
No problem. Good morning.
Oh, good morning. Good morning. Good morning, Mr. Dodd. Welcome to the first hearing of the Ethics Commission. My name's Kathleen Lickers. I'll be chairing today's hearing, along with two other members of the Ethics Commission, my colleagues Daniela Carapi and Arlene Henry. The three of us are the composition of the Ethics Commission. Today's hearing is in the matter of Victor Bonspille and Valerie Bonspille, whom we'll refer to as the appellants, and the Mohawk Council of Kanesatake, whom we will refer to as the respondent, in our matter number 001-025 on today's date, March 17th, 2025. We've been advised that the appellants are not represented today, but I'll invite you to speak to that as well as your other submissions, Mr. Dodd. And Mr. Dodd, you are representing the Mohawk Council of Kanesatake?
That's correct.
Great. Thank you. I just have a few preliminary remarks technically because we are proceeding virtually, and then substantively to give you to provide some background as to how we arrive at our hearing today. The hearing is open to the public and it is being recorded, and the recording of this hearing by any of the parties, attendees, or members of the public is strictly prohibited. This is a virtual hearing, and so I'd like to outline a few details before we begin. Your microphones and are enabled by the communications director. There will only be one speaker at a time. Everything else is muted. I would like the speaker whom is speaking to center themselves in the frame of their screen so that all participants can see you clearly. Please speak slowly. Ensure that only one person is speaking at a time. We are going to carry out the hearing in English. As one person is speaking, we want to prohibit anyone from speaking over each other. So please, I would appreciate if you could use the raise your hand feature and wait to be acknowledged before speaking or objecting. All participants are muted when not speaking. During the hearing, the commission panel will be taking notes, so we may be looking away from the camera from time to time, but please note that we are very much engaged in listening. Obviously, there may be some technical glitches. This is a virtual hearing, and so if we do, we hope that we can count on your patience and tolerance for any issues that might occur. If anyone is disconnected, please be assured that the hearing itself will pause until you're reconnected, and reconnect using the link that was provided by the communications coordinator. If the video of any of the parties becomes frozen, please alert me as the chair, and we'll pause until the video can be unfrozen. Here is how I expect the day will go. I, as chair, will introduce the Ethics Commission, and as I said, the steps taken that lead us to today's hearing. I will invite the oral submissions of the parties who are in attendance for 30 minutes, followed by questions from the panel. The hearing will then conclude. It is not our intention to decide the matter today, but we will reserve our decision, and pursuant to our terms of reference, we will deliver our decision with written reasons to the parties by March 31st, 2025. Before I begin with the outline of the commission and the steps taken to today, are there any questions, Mr. Dodd, of a preliminary matter? Okay, let us begin. The background to the commission. The decision to establish the Ethics Commission was discussed by the Mohawk Council of Ganasatake in the spring of 2024, and draft terms of reference were prepared by July 16th, 2024. Pursuant to these terms of reference, the Ethics Commission was established to uphold the integrity and ethical standards of the council members as outlined in the Electoral Code, particularly Section 9, which addresses vacancies, dismissals, and appeals due to various reasons, including criminal offenses, misconduct, failure to fulfill functions, and uphold duties and absenteeisms. That I'm referencing paragraph 1.1 of the terms of reference. The Ethics Commission shall serve as an impartial body and ensure fair treatment of appeals submitted by dismissed council members. And that I'm referencing paragraph 1.2 of the terms of reference. The commission is comprised of 3 members whom I've introduced to you this morning, and was fully constituted by October 7th of 2024, when each member was appointed by the Mohawk Council of Ganasatake, and we had signed our respective engagement letter. The official version of the Ethics Commission's terms of reference were formally signed November 29th, 2024. Today's matter concerns Victor Bonspille and Valerie Bonspille, again, who we will refer to as the appellants. The background to today's hearing. The commission has been verbally advised by the MCK Consulting Communications Officer that the commission was being called upon to hear an appeal as contemplated by Section 9.6 of the MCK Custom Elections Code brought by Victor Bonspille and Valerie Bonspille. On January 9th, 2025, the commission issued our first procedural direction outlining the timetable for an orderly exchange of written submissions of evidence and arguments by the parties. The direction was communicated to the parties on January 13th, 2025. On January 14th, 2025, the appellants acknowledged receipt of this first procedural direction and communicated their request to the commission for an extension to mid-February for the parties' exchange of submissions. And I quote, "in order to meet with our legal representative and provide our submissions and positions on the issues," unquote. The commission granted this request, and in our second procedural direction, issued on January 21st, 2025, we outlined a revised timetable for the orderly exchange of written submissions directed to today's hearing. The appellants, Victor Bonspille and Valerie Bonspille, were given until February 14th to provide submissions to all parties and the commission. Nothing was submitted by the appellants. The respondent, the Mohawk Council of Ganasatake, was given until February 28th to provide their submissions to all parties and the commission. This timeline was met, and we have the submissions of the Mohawk Council of Ganasatake provided by Mr. Dodd. Again, based on the second procedural direction, the appellants were given until March 7th to submit to all parties in the commission a reply to the respondent. Again, nothing was received by the appellants by this deadline. On March 11th, 2025, the MCK Consulting Communications Officer was provided with a letter via email dated March 11th, 2025, to deposit with the commission for our records. In the letter, Victoria Bonspille and Valerie Bonspille, through their legal counsel, Mr. Robert Lord, advised that they will not be attending today's hearing and that they have no representations to make other than what was contained in the letter. Mr. Dodd, we now invite your submissions and any response that you may be able to provide the commission to the March 11th letter of Mr. Lord on behalf of the Bonspilles. Please go ahead, Mr. Dodd.
Well, thank you, commissioners. It's an important moment, the first hearing of the Ganasatake Ethics Commission. And so we appreciate you pulling this together and being here to hear this important matter. So what I propose to do, because the hearing is public, but people have not necessarily seen our written representations, I propose to run over them again. And so that will be a bit of a recap for you, obviously, because you've already read them. But I think it's important to give everyone listening context and structure to any further submissions we make. So I'll do that first, and then I'll make reply points to the letters submitted by Maitre Lord on behalf of the appellants. So as you know, in our submissions, we tell the commission there are really two questions before it. The first question is, have the appellants vacated their seats as a result of not attending more than 3 council meetings without a valid excuse in accordance with section 9.1.5 of the Ganasatake Custom Electoral Code? And the second question is, have the appellant's seats become vacant because they've engaged in wrongful conduct that affects, interrupts, or interferes with the performance of their duties? And that's in accordance with section 9.1.6 of the Custom Electoral Code. So, as you know, the council submits that the answer to both of these questions is yes, that both provisions of the Custom Electoral Code have been infringed by the appellants, and that the commission should declare that their seats have been vacant since February 27th, 2024. So, of course, the first thing to talk about, I think one of the most important things is the code. The Mohawks of Ganasatake Custom Electoral Code. Because it's important to remember that these are rules the community has set for itself. These are not rules imposed from the outside. There was a committee formed by the council in 2013-14. It conducted meetings and consultations with different groups within the community, and the code was drafted, amended, and then put to a referendum vote. And as we see in the resolution, that is the first few pages of the code, that referendum vote was approved. So that's a very important thing to remember, because there can be sometimes there seems to be this suggestion that the code is not part of the community's rules, but it is. It has its genesis from within the community, and it's been used on 3 occasions now. In the general election in 2015, the general election in the general election in 2017, the general election in 2021, and the by-election in 2023. And what I think one of the things that is underlying this affair, which is very important, is the idea that once set down, the rules have to be respected. And that doesn't mean they can't be changed. There is a process in the code for changing the rules if the community decides that these rules no longer suit it. But the important thing is once those rules are in place, that we respect them. And that's because there is an election coming this summer, right? And this code will be what governs that election. And it is very important that, everyone knows that these are the rules we are going to use. Because as we know, once you start disagreeing on the rules, there can be a real failure of civil society. And in the very heightened political tensions we have within the community of Kanesatake these days, it is more important than ever that there's a set of rules that everyone knows will apply and that everyone knows will be enforced. And that second part is also very important. So I think the commission's job is of a serious nature, because it is about the question of, is there a set of rules that is enforceable and that people will be held accountable to? The other thing I wanted to mention as a preliminary point is that we're here because the appellants asked for this appeal. Right? Like it's and I think that has to frame kind of your reflections, is that the reason the council brought this commission together is because an appeal was requested by the appellants. And the council worked very hard to put this commission together, to collect, the commissioners, yourselves, to form an objective and independent body to hear the appeals, because it takes due process and fairness seriously. It wanted to respect the code, and it wanted to respect the appellant's rights under that code to an appeal. And so that's made significant efforts to do that. But unfortunately, the appellants have decided, having asked for it, have decided not to participate. Finally, I just wanted to mention on the enforceability of the code that, as mentioned in our submissions, the appellant Victor Bonspille, who was on council at the time the code was adopted, signed the resolution approving it. And he was elected in 2017 and 2021, as was the appellant Valerie Bonspille, under that code. So any question of, does it apply or not, I think there's absolutely no question of that. And we already have a federal court judgment enforcing its provisions. So, the procedural background of the appeal commissioner Lickers has already covered that. So I don't feel like I need to go into that. So I'm going to go straight into the issue of, have the appellants infringed 9.1.5 by not attending council meetings, about 3 or more council meetings within their mandate without a valid excuse? And are their seats vacant as a result of that? And of course, the council submits the answer to that question is yes. Essentially, and it's important to underline here is that no one denies the facts. The appellants have not been attending council meetings since essentially August 2021. So there's no denial of facts. The appellant Victor Bonspille admitted in his examination for discovery in the Superior Court file that he has not been attending council meetings, and he hasn't bothered calling council meetings since, and in that case, the question was since January 1st, 2023. But it was very clear, at least for the 18-month period before that, that he had not called or attended any council meetings. But the problem is that this is not what the code says. The code, and I'm not sure if I'm able to share my screen, but the code does not distinguish between grand chief or chiefs when it makes the rule that everyone must attend council meetings. It's a rule for everyone, and it's a rule the community put into place because that is what council members are elected for. They are elected to go every week to council meetings to conduct the business of council. That is why that rule is in place, because that is the expectation. When you're given this, position, which to which respect and a certain amount of honor attach, to which you're paid, for which you are paid a salary, a full-time salary, you are expected to do that job. And the key part of that job is attending council meetings, where business of council is discussed and important decisions are made. So that is why the rule is in place. And deciding, essentially what the appellants have done is they've decided they don't want to attend council meetings because they don't agree with the other members of council. And that is not a valid excuse. The entire point of governing democratically is that there is disagreement. That we sit down together and we try and work on the issues, even when there is disagreement. And you won't always win every point you make, but the important thing is to be there and have the discussion and make the arguments you want to make. So the idea that because they appellants weren't able, they felt to influence the decisions of council is not a valid excuse for not attending those meetings. Moreover, that closes any opportunity for things to improve. If, at least when you're sitting at the table, there is an opportunity for minds to start to change, for people be able to start to see ways to collaborate, at least on certain issues. But when you're refusing to even sit at the table, that closes, that eliminates that opportunity, and it makes division and it makes the divisions even more severe and even more unbridgeable. And as you know, there's no other excuse here, because as we provided the commission evidence, both appellants have been traveling all over the province and to Ottawa to meet with federal government officials, provincial government officials, holding themselves out as representatives of council, despite the fact that they're not attending meetings and not doing their job within the community. So it's not a question of there's some other bar on them being able to attend council meetings. So key to the submission, or their position, as I understand it, is that only the Grand Chief can call council meetings. So that means that any council meeting that isn't called by the Grand Chief is illegitimate, and therefore missing that meeting doesn't count against the three, is essentially, as I understand it, the appellant's position. But first of all, we know that position is wrong, because there are many examples in the past practice of council that shows that the Grand Chief has not always been part of the governing quorum, but the governing quorum has continued to adopt resolutions all the same. And we provided the commission with a package of resolutions that were adopted in the early 2000s when the older brother of the appellants was a chief, and he had no problem calling meetings with the other members of a quorum who were in disagreement with the Grand Chief at the time and adopting resolutions. So you have a whole package of resolutions there adopted without a Grand Chief's signature and without agreement of the Grand Chief, by meetings run without the Grand Chief. And the appellant's older brother participated in that. And that same situation has happened several other times in recent history in Kanesatake, where the Grand Chief is not in agreement with the quorum, but council continues to function. Because that's the thing. If this position were correct, it would essentially amount to a veto of the Grand Chief. It would mean that, as here, since the Grand Chief knew that he would not be able to win every point he wanted to win, he simply stopped calling meetings. And that is not one member of a 7-person council. That's a person with an effective veto. And there's absolutely nothing in the custom electoral code that suggests that this is the case. Moreover, the rule about attending meetings applies to both the Grand Chief and the chiefs. But if the Grand Chief could cancel every meeting that they didn't want to attend, that rule, there's no reason to apply that rule to them. So everything you have in the code mitigates against the position adopted by the appellants. Moreover, where you say something is a customary rule, it's up to you to prove that custom, because there's nothing, as you've seen, there's nothing written down anywhere to support the appellants, but they say, well, it's a custom. But first of all, where you allege a customary rule, you have to prove it. And most importantly, the rule for proving custom is that there's a broad consensus. The rule has been used in regularly in the past, and there's a broad consensus about its application. Well, you absolutely clearly do not have that here, because many times over the past, their meetings have taken place without the Grand Chief. And moreover, you have five members of council who do not believe that's the rule. So I don't think there's any ability for the appellants to demonstrate a custom within the meaning of that, how that has been defined. One thing I like to say is that, and it's not exactly right, but custom doesn't need to go to court. It doesn't need to go to court because everyone already knows what it is and agrees on it. And and for example, one of the current members of council, Chief John Kanatonkin, has been on council for a very long time. He has had many, many mandates and had been on council for a very long time. And if anyone were to know if there was such a custom, it would be him. Yet here he is governing with the quorum because he knows there is no such custom that would give the Grand Chief an effective veto over everything council was working on. So the other point, or it's raised, we addressed it in our submissions because we knew it would likely come. But one of the points raised by Mr. Lord in his letter to the commission on this point is that, well, the council, none of the meetings could be valid because the 5 members of council that have been doing them were removed by votes of non-confidence in the fall of 2024. And he submits that that's also the reason why this commission itself has no legal validity, because it was adopted by, put into place by council members that have in fact been removed. So the rule in public governance is that we presume the validity of the actions of a public government until we're told otherwise by a court. And the reason that is a rule is because people rely on the decisions of public governments. What the appellants are effectively saying to you is that nothing the council has done in the past 18 months is valid. That means funding agreements aren't valid. That means the allocation of lands within Ganasatake to band members are not valid. That means hiring of employees are not valid. If you take this position that all these actions are not valid, you throw the lives and businesses of many, many people into turmoil. And that is why the rule is, if you believe a public authority is occupying its post without legal reason, you go to court and you make that case. And the federal court hears these cases all the time. The federal court has jurisdiction to remove people who are illegally occupying posts within a band council office, and they hear those types of applications all the time. The appellants have chosen not to do that. And I submit they've chosen not to do that because they know they do not have a good case. And but until such time as a court has ruled that there's an invalidity of the people in these roles, we have to presume their decisions are valid because it's the only way that the system keeps working. Moreover, there's already a federal court decision that explicitly says there is no custom of votes of non-confidence by raised hands in Ganasatake. The issue has already been decided. That doesn't mean another custom could be established. The code allows for the establishment of a vote of non-confidence process. And if that eventually is done in a correct way after consultation with the community and a vote by the community to establish such a process, perhaps such a process could be put in place. But there is absolutely not one at this time. So I'm not sure, I apologize, Madam Commissioners, I've lost track of my time a bit here. How much more time do I have?
I have another 8 minutes,
Okay.
Mr. Dodd, but take as much time as you need. It's important that we have a full understanding. And if I can, when you are making reference to either a legal precedent or a rule, can you be sure to provide us with the source or site that you're referring to? For example, the last reference that you just made for the issue to having been determined in Ganasatake, can you, by the federal court, the show of hands issue, what case are you referring to?
That's the Gabriel case, I believe, and I can find it because it's cited in our submissions, so I can find that for you. Yeah, Gabriel v. Mohawk Council of Ganasatake, 2002 FCT 483 at paragraph 15.
Great, thank you.
So I'm going to move on then quickly to the second issue, which is the wrongful conduct of the appellant. So the violation of section 9.1.6 of the Electoral Code. And so the code says, the words of the code is, the seat becomes vacant if a grand chief or chief engages in, quote, wrongful conduct that affects, interrupts, or interferes with the performance of their duties, end quote. So we submit that, to help understand that, what is wrongful conduct, to help give meat to that idea, there are two principles that the commission has to keep in mind. The first is that the code requires the council to act with, quote, honesty, impartiality, fairness, and openness in the interests of the Mohawks of Ganasatake. And the second principle is that we all know that when you are elected to council, you take on a fiduciary duty. And you have to put the interests of the community and of the band ahead of your own personal interests. And and if you want the case law on that, that's in footnote 17 of our submissions. So there was a resolution adopted by the council in June of 2023, laying out the various actions which the council believes that the appellants have done that constitute wrongful conduct within the meaning of this provision. But we're only, as you saw in our submissions, we only focused on 3 of those. Okay, and that's what we'll do again here this morning. And so the first one is the request submitted by the appellants that the community be placed in third-party management. And I have to, perhaps a bit of editorializing on my part. That's one of the most shocking things I've ever seen. Third-party management is horrible. It destroys the administration. it destroys a band's ability to make decisions for itself about its priorities. It goes against everything we have been trying to do in the last 30 years, which is to give Indigenous communities more autonomy. And to ask that the federal government come in. So what happens in third-party management is that essentially, as you may or may not know, the majority of council, the vast majority of council's operating funding comes through funding agreements with the federal government. And that money is usually in envelopes. So there'll be a housing envelope and a social assistance envelope and an education envelope. And there's rules about how these envelopes work. You can't spend money given to you for education on housing, for example. The envelopes are separate. And in addition, there's a band support fund, which allows the band to pay its employees, to pay the elected members, and also like money that it can spend on getting an environmental study, for example, or it's flexible money that allows the band to focus on its own priorities. But when third-party management is imposed, all of that is gone. First of all, the money no longer comes to the council. The money goes to a consulting firm, a non-Indigenous consulting firm. Something like KPMG was the third-party manager for Ganasatake 20 years ago or so. And that consulting company decides what happens, essentially, decides what council's priorities should be. And it does the bare minimum of keep making sure that the absolutely necessary programs run, but nothing else. Meanwhile, reaping fees for this work from money that should be going to the band. So that is an extremely serious thing that the federal government only imposes in the most drastic of situations. And yet here we are where the appellant sent a letter to the Minister of Indigenous Services asking that third-party management be imposed, not because they believed that, and this is something that was confirmed with appellant Victor Bonspille on an examination, not because they believed that the band was in serious financial trouble, not because they believed that money was being stolen from the community, but simply because they were frustrated that they did not have a role in making certain decisions about how the money was spent. That is, I submit, a violation of their fiduciary duty. They are putting their personal political interests ahead of the interests of the community of the Mohawks of Ganasatake. Because there's not a single person, there will only be harm caused to everyday band members by the imposition of third-party management. But the appellants invited and requested that harm be imposed on their band members because they had a political disagreements with the other members of council. And for in council submission, that's the very definition of wrongful conduct. It violates the fiduciary duty, and it violates the principle that a council member should work for the betterment of all Mohawks of Ganasatake. The second issue addressed in the wrongful conduct portion of our submissions is the physical assault of Chief Denise David by appellant Valerie Bonspille. So you will have read, we submitted to you as one of the documents, Chief Denise David's written account of what took place. If you've read that written account, you see the extent to which things have been difficult within the relationships between the different members of council. But, no one is asking, nobody is suggesting that everyone should get along all the time and hold hands and sing Kumbaya. This is politics. It's rough and tumble. You can say, you can criticize in very, very strong terms your political opponents. That's part of the game. That's what everyone should expect when they run for public office of this nature. But being physically attacked crosses the line. within and physically attacked within the council offices. And I don't think there's any, I mean, we agree as a society in general that using physical force against another person is wrongful conduct. So I don't think there's any real question that must be seen as so within the meaning of 9.16 of the code as well. Now, the third issue on the issue of wrongful conduct is the chaining shut of the band council office doors. So as you know, we provided the commission with legal proceeding that was filed in relation to those events. And so, as you know, there was a meeting on the evening of October 24th. And the appellants claim that this is one of the meetings at which the other five members of council were removed. And the next morning, first thing the next morning, the appellant Victor Bonspille was in the parking lot. He came into the building. He told all employees that were already there to leave the building. And then he stood with appellant Valerie Bonspille with about a dozen other people with chains were wrapped around the band council office doors. Those chains would stay there for approximately 10 days. And they were only removed once the council members were authorized to do so by a provisional injunction issued by the Superior Court. And in that, we've given you that decision, and the judge is very clear. There appears to be no legal grounds whatsoever to justify, or not. That's not exactly right. It isn't stated exactly right, but it's very clear for the judge that interfering with council operations in this way risks causing very serious prejudice to the people of Kanesatake. And the thing about it is, again, this is not the kind of behavior that should be condoned in any way. Because if you want to hold a vote of non-confidence and say that it is legally enforceable, that is fine. Then your next step is to go to court to have that right vindicated. Your next step isn't to take the law into your hands and try and force people to see things your way. And it's very, I think that, you know, especially in society in general at this time, it is extremely important that we maintain the idea that a person should not take the law into their own hands. You know, we've seen, you know, attempts to overthrow democratic governments many, many times, unfortunately, over the past few years. And in that context, it's more important than ever to say no. You know, if you believe that there's a problem here, you go through the proper channels to do that. You go to court and you say, these people have been removed, order that they cease holding those posts. And if the court believes you've made your case, you'll get your order. But you can't go throwing people out of buildings and chaining the doors shut. And that taking those actions ignores the difference between the political aspects of council and the public government aspects of council. The fact that people rely on council for their social assistance payments, for snow clearing, for making sure, like, authorizing work to bring internet access to different parts of the territory. This is all important public work that the council is doing, and that is only stymied by these types of actions. So each of those three issues in and of themselves constitutes wrongful conduct. I think taken together, they form a very powerful package. And they show that the appellants have failed to respect the obligations of fairness, respect, openness, democracy, and community interest before personal interest. So regarding, you've seen in the letter submitted by Mr. Lord that he says, well, this issue of, the validity of a supposed vote of non-confidence is before the Superior Court right now. But we submit to you that issue isn't before the Superior Court right now. The only issue before the Superior Court right now is whether the council has a right to an injunction to prohibit people from trying to shut down council operations. The defendants in that case have said they want to raise that issue in their defense, but as far as we're concerned, it's completely irrelevant. Because even if you're right that there was a vote of non-confidence that removed the other council members, which, as we've explained to you, we don't think there's any case for, even if you're right, it still doesn't justify shutting down the public government. So I strongly suspect that issue, the court's just not going to deal with it because it's going to see it as irrelevant. Secondly, it's very clear that that's an issue for the federal court. The issue of whether someone validly occupies a federal post is something within the exclusive jurisdiction of the federal court. And I don't think the Superior Court is going to want to wade in on that issue, particularly where it's irrelevant. So this whole idea that, you shouldn't decide because it's going to be decided by the Superior Court, I don't think has any merit whatsoever. So I think that brings my submissions at this time to the end, though I look forward to answering the Commission's questions. So what, of course, the Council is asking for are confirming that in accordance with 9.1.5, the appellant's seats have been vacant since February 27th, 2024, as a result of their unjustified absences from council meetings. In accordance with 9.16, that the appellant's seats on council are vacant because they engaged in wrongful conduct that affected, interrupted, and interfered with the performance of their duties. And a confirmation that since they've not been, since their seats have been vacant since February 27, 2024, they are to return all council property in their position and any economic benefits they have received since that time. So those are our first submissions, and happy to answer the Commission's questions.
Thank you, Mr. Dodd. I'm going to first turn to my colleagues to ask Ms. Henry or Ms. Karapai, do you have any questions for Mr. Dodd?
No questions from me at this time. Thank you, Mr. Dodd.
Yes, I have no questions either. Thank you, Mr. Dodd. That's great. Thank you.
I have a few, Mr. Dodd, if you'll beg my indulgence. I want to go back if I can. I just want to be certain that I have the record complete on your submissions, as there's references that you make in your submissions and then footnoting, but we don't have the complete narrative. So I'll give you an example. In your submission, which you very kindly went through both for us and for the members watching, in paragraph 6, when you make reference to the February 27th resolution, that's the date by which MCK would say vacancy is initiated at some measure by February 27th. Do you have that actual resolution? Can you provide that resolution? It wasn't attached.
Oh, yes, I'm sorry. I had understood the Commission had received that. It's my sincere apologies. I'd be happy to provide that.
That would be helpful if you could follow your submissions today to the communications coordinator. That would be helpful. Going forward, I have a couple of questions. The no one denies, when you make the submission, that no one denies the non-attendance or the absence. You are, for us, importing into the record the deposition of Victor Bonspille in the Superior Court's injunction, provisional injunction matter. That record is the record that you're relying on to say that fact is uncontested, that admission is what you're relying upon, that public record you're bringing in. Okay, that was That was one point of clarification. Then going forward,
I would just add, Commissioner Lickers, that I think it's also admitted in Mr. Lord's letter.
yes, and we are going to accept Mr. Lord's letter for the record that he asked it be brought into the proceedings. He asked that be put onto the record for the commission's proceedings.
Yeah, but I think he says something in there along the lines of, well, of course they haven't been going to meetings, they're just shouting matches. So I see that as an admission also that supports that fact.
Okay, thank you. I want to go to the questions that you've put to us, or the issues that you've put to us in the 1.9.6, the wrongful conduct submissions. You have drawn out the issues around Victor Bonspille seeking third-party management and the reasons for that. Just to be clear, the decisions that were made that may have prompted his request were decisions that would have required his attendance at council had he been involved in these decisions around financial matters, correct? So if he's not attending, his attendance would have been required. He could have participated. They weren't decisions being made separate from council in your examination.
No, that's right.
You're giving us a list of examples of things that they would have been deciding upon, land allocations, etc. These are decisions that would have been happening in council business that he could have participated in. So
that's right.
So correct?
Well, that's right. So one of his key concerns, based on the excerpts of the examination we provided you, is what legal fees council is incurring, but all mandates to lawyers are approved by council resolutions that are discussed at meetings.
Which would have these meetings taking place in the time period that we're examining whether there's vacancy or not. These are decisions that are in this time period.
Yeah, absolutely.
Okay. Going forward with that your same submissions, the physical assault on Chief Denise David, were criminal charges laid?
Chief David did make a report to the police. That's why you see there's a number for a complaint number.
Mm-hmm.
I do not know, I admit, what follow-up the police have made on that complaint.
Okay, that's fine. Thank you. And I think you made reference in some ways to this, my last question. The submissions, the evidence that you've put in before us that support the provisional injunction leave the question open as to what has been the outcome. Is the application ongoing? Your last submission to us was that the Bonspilles are continuing to pursue matters in the Superior Court. Is the permanent action ongoing?
Yes. So what happened with that is that they were being represented by Mr. Lord in that matter, the defendants. But then he, how do you say this in English? He removed himself. He right before our deadline to file for trial readiness, he cessé d'occuper. I don't know how you say that in English right now. Okay. He filed a thing saying, "I'm no longer the lawyer for the defendants." So we asked for the court for the issue to be set down for default judgment, but the judge at the time, some of the defendants came to that hearing, and the judge at the time felt it would be better if she gave them more time to find another lawyer. And so just 2 or 3 weeks ago, Mr. Lord came back. So the action was on ice. Now he's back. There's a roll call at the end of April, but so yes, it is still there. And it seems that there perhaps in April there will be hearing dates set down. But that's where that file is.
So the matter before the Superior Court continues, as you've just described. Is there anything that is currently in the federal court?
No.
Okay. Those are all of my questions. So thank you, Mr. Dodd. If there's anything that follows from my colleagues to anything that I've asked, is there anything that might have prompted questions? No. Okay. Well, I think that brings our hearing and on both of the written submissions. Mr. Dodd, thank you again, as well as the oral submissions that you've given us this morning. As I said at the beginning, we will reserve our decision and undertake to deliver our findings, our reasons with findings in writing by the 31st of March. With that being said, we are adjourned. Thank you.
Have a nice day.
You too. Thank you.
Thank you.
Wonderful.
Justine, can you take the commission to its hearing room, please?
Yes, do that right now, which should be on in a few seconds.